Hello, everybody. Billy's helping. Helping. Okay, guys. How's the colors tonight? Are they better? Oh, I'm so happy you're here, Army Brat 1964. We all are. Hello, Nana Laura. Hello, C-Rex. Hello, Linda Applegate. Oh, lurk away, my dear. Hello, Ginny. Hello, Mortimer Duke. Is it still real bad? Oh, thank God. Oh my gosh. Oh, now you're just being picky. Oh, well, I mean, I do have. Let's see if I can get this to turn on. That's red, green, blue, orange, yellow, green, teal, light blue, lavender, brighter lavender. Okay, pink, brighter pink, white. What does that do? Well, that's bright. I don't like that. Dimmer. How's that? How's that? I don't like it. Hello, Margot. Hello, K-John Boom. Well, okay, I'll get the handyman over here to paint it. Oh, no. I liked it better when my blanket was the other way. It had like a brighter pink on the bed. Hello, she's a maker. Hello, Spider-Man love. Oh my gosh, really? You guys liked the blue? Okay, hold up. The blue like that? Oh, wait. Or that blue. It's too much blue. All right. Oh, maybe I'll have to look into that. See, my computer gives off a blue hue as well. Oh, there's my helper. I like that one. I'd be acceptable with that one right there. Like that's as good as I can. That's what I can do. Okay. Now we're going Charlie and the Chocolate Factory. There was nothing better than the original. Like you just can't beat Gene Wilder for that part. Like they tried, but no. No, I love Johnny Depp, but Gene Wilder nailed it. Nothing better than the original. All right, girl. Whoa! You'd think I had treats or something. When I was on the blue setting, I was too blue, but the next click was good. I don't want to go through them all again. Munchie bone. Twisted Munchie Bone. I got the kitty cats. Their order came today. So they have, oops. You did not eat the whole thing, you little liar. I got the Jackson Galaxy Gotcha Wand. It, like, I can choose how long the string is, and then it retracts, and it's got the this is so great. This is the best cat wand I've ever had, and they love it. And then I got 2 of the bottles are out in the kitchen, but I got 2 bottles of the bully solution, which is supposed to help make them less dominance aggressive. I got a bottle of the self-esteem, and then there's another one for bully solution, and then there's one more, which is Peacemaker, for you add it to their food or water dishes for the community bowls, and it helps, dogs and cats get along. So I got a set so that hopefully we can get this little argument between the PAWFURM to kind of settle down, because Bandit lives under the bed and the cats are always arguing. No, Ava, let me put them away, please. No, wait. You wait. Ha. Yeah, real life catfishing. That's perfect. Excuse me. Hello, Charlie. Yeah. Hey, that must have been a twofer. Every day here is wild and crazy. Oh, man, I wish I hadn't given her all those. I forgot. I got at the gas station last night. They had rabbit sticks for dogs, and then they have these beef jerky for dogs. And so I picked them up for her. I was going to give them to her tonight. I gave her 1 rabbit stick last night, and she loved it. They're supposed to be crunchy. Like, they've got crunchy, chewy rabbit goodness, I guess. I don't know. I didn't taste it. Oh. Oh my gosh. It's a night and day difference. Like, I was planning on coming on earlier today, but I couldn't find any content. But otherwise I'd have been here earlier, because I can do so much on it now. But the only thing that I can't do is magically make good stuff happen. I'm just mom. That's all. I'm mom. Every one of them acts like I'm mom, and they get jealous accordingly if I'm petting any one of them too long. Yes, that's exactly it. Chop chop. Mortimer Duke has spoken. Oh, okay. You can do that. Cat noises. I have, let me see. I gotta see if I put it where I think I put it. I might not have what I'm thinking I have. Don't listen to me. Just pretend that I'm making sense at the moment. Yay! I did put it where I thought I did. Okay. So I've got Judge Gauthier, something like that. One of those two. So I have a docket with him that I did a couple days ago, and then I have tonight's docket as well. So we're gonna have, it's gonna be about an hour and a half worth of court tonight.
People be Hilliker. All right, this is file 24-93314FH. And Mr. Gilbert, have you had a chance to review the probation recommendation report with Ms. Hilliker?
Yes, Ms. Hilliker and I did go through that report.
Okay, any additions, corrections?
Oh, Your Honor, it was not necessarily on the factual basis, more of an allocution.
Oh,
so,
go ahead.
So, Your Honor, my client did want me to point out that she is employed, even though the recommendation says that she's not. She's gotten a job with a food truck that services the Onaway area, and also I believe goes over to Emmett and Sheboygan counties, and that she'll be working on that full time. If I may, my client wanted me to present to the court a picture that she colored for the judge, if I may approach.
Sure.
She colored a picture for the judge. Like the toddlers color for their doctor in the waiting room.
And I know my client is, and I believe my client coloring a picture for the court says a lot in its own right of her cognitive issues and trying to get her arms wrapped around her addictions and what that's done to her over time. I know she's trying on her own accord to see if she could possibly get some sort of inpatient counseling and counseling called. I understand. Okay. Is that some sort of treatment to help her with her addictions, counseling and drug treatment. And I would ask the court to take that in consideration if the court were to sentence her to some form of incarceration for her failure with a quick and sure. She's well aware that she's in this situation because of her own doing. She didn't come to court and she knew she had to come to court. I would ask that the court possibly allow her to do, while she's sitting that term, any type of jail set term, to do some sort of inpatient treatment as part of her any type of sentencing. But I would ask the court possibly, I know it's really asking a lot because Ms. Hilliker was warned and that she needed to come to court. She didn't. I know I've been in contact with her that day and she wasn't able to find a ride. She had even told me that the day before that she was having issues. I would ask the court before they remove her off probation. I'd really like to see her get more help. She's been fighting this for a long time. Ms. Hilliker's been on my client list a long time, and it's all because of her addictions. And I just have to ask the court to take that into consideration. Thank you.
All right, thank you. Ms. Hilliker, you don't have to tell me anything, but you're allowed to. Is there anything you want to?
I'm sorry that I didn't take, I guess, responsibility and come to court. I tried. I waited outside the courthouse that day to be sentenced, to be told to come back the next day. I really tried to find a ride, and then even after the fact, trying to find a ride. I know that's my responsibility, and I am trying to pay off my fines to get my license back myself. And I do have a job with my stepmom, working the food truck, and she would be my ride to and from to go to there. So, and I have reached out for a dual treatment center for mental health and for inpatient rehabilitation. I just ask that you take it all into consideration. Thank you, Your Honor.
Thank you. All right, Mr. McClellan.
Thank you, Your Honor. I can understand having some hiccups and slip, but Hilliker has had a tortured history here so far on probation. There's been multiple positive tests. There's an allegation of attempting to falsify a drug test. Failure to appear, at least. Me, really, reading the probation recommendation report here, what stands out is it's noted that Ms. Hilliker has not shown remorse. She doesn't appear to have any goals to get sober. There's just been violation after violation, Your Honor. appears to be generally poor attitude.
All right, Ms. Hilliker, I share a lot of the sentiments that Mr. Gilbert said. I mean, I agree with a lot of what he said, which is why we've been trying to do what we've been trying to do with you.
Oh, I have
But,
been trying, even though it doesn't look like it.
Well, it sure doesn't.
I know.
Probation is sort of a two-way thing between a court and the defendant, where instead of locking you up, we're trying to address the issues that are causing these problems in your life. You had at least 2 pending contempts while you're on bond for positive tests. We ended up revoking your bond. Having a criminal charge over your head didn't stop you from using, which is not terribly surprising. I get that. So that's why then we still put you in the Swift and Sure probation program, which is the most intensive probation program that we have available in Presque Isle County. That's an intensive probation into your life. This designed to connect you to treatment. And you've got Miss Barth and Agent Flesh, both of whom are great people who care about the people in their program and trying to work with you on that. And we had several violations where you weren't working and you weren't doing the community service. You weren't testing at one point. You still didn't turn in your community service hours. We had some positive tests. And in the Swift and Sure, we give you 3 days jail if you have a violation. So we were all set last fall, give you 3 days jail, but you didn't show up. So then we had to do a warrant for you. And then you ended up doing, I think, 38 days before it got all resolved. And we still kept you in the Swift and Sure program. And then you got violation. You had a violation in January and we gave you the 3 days. Okay, so we're still working with you. Then you get another violation for a positive test and attempting to falsify the tests, which shows you're not super interested in, treatment because you're trying to avoid getting caught.
Scary.
And I know it's scary, but we're trying to work with you. And then still the plan would have been give you 3 days and keep working with you. And you just don't come. And then it's not just that you didn't come that day, then you just stop reporting, until you get arrested on it. So I don't know what else we can do. I mean, probation can't be a one-way street with me and Miss Barth and Agent LaFleche trying to help you and you not cooperating. So that's not working. So I got to revoke you out of the program and revoke your probation. I wish we could get you some treatment, but we tried. So at this point, you're a young person. I had notes to myself at the sentencing last year that you were early on the meth road. Well, you're further on it now, reading in this that you can't even find a vein, so you got somebody else shooting it into you. Think about that. You colored me a picture, which, as your lawyer said, shows that you've got sort of a childish way of looking at this, and I agree. But it says, well, he didn't say it that way, but that's what he was hinting at. For through wisdom, your days will be many, and years will be added to your life, out of Proverbs. Meth does not add wisdom, days, or years to your life.
No, not mine, but.
It will shorten your life. Methamphetamine is going to make your life miserable and short. So I sure hope that you decide you want to make some changes. If you do, you don't have to be on probation to go to treatment. So when you're out of jail, get yourself to treatment. If you catch another case and a judge wants to give you a chance like we did, take advantage and cooperate. But I can't do anything else with you right now other than give you some jail time. So I'm going to revoke your probation, or you serve 6 months in the Presque Isle County Jail, give you credit for 85 days previously served. Any fines and costs that were due and owing remain due and owing in the amount of any unpaid balance. So That's the judgment of court. If you want to appeal, you can file an application to the Court of Appeals. So we're going to hand you a copy of your appeal rights right now, ask you to initial one. If you want to file an appeal and want a lawyer, you have to make that request to me within 6 months. So when you're released, Madison, you're not going to be on probation. So when you're released, you do what you want. But I sure hope that you reach out to somebody and get into treatment. Go to NA meetings, go to Celebrate Recovery, go to AA, go to something, go to Thunder Bay counseling, go to inpatient. But that's all on you. We've tried, and us trying hasn't worked with you. So I hope I don't see you on another case. I hope I don't read in the paper that you've overdosed. I'm worried about all those things for you, Madison. But good luck.
I'm really afraid for her future. Without intervention of some sort, she's not long for this life. She's so down bad that she was having someone else administer the drugs to her. That's just crazy to think about. And shame on that person. My guess would be maybe something, trafficking. For some reason, someone wanted to keep her on them. That's a level of dedication that exceeds anything normal. Hello, Crystal Canarium. Yeah, no kidding. Oh, hi, Ava. Hello, Rocky Lennon. What, do you gotta go potty? Or you just want love? You just want love, you big baby. You big baby. Oh, I meant to click on you, Rocky. I'm sorry. Hello, sweetie. Yeah, no kidding. Yes. 100% right there. Agreed.
All right, Mr. Gilbert, we've got Tammy Krajewski.
She's ready to go, Your Honor.
Am I pronouncing it close to right? Krajewski. Oh, all right, Ms. Krajewski, want to come forward? All right, this is an arraignment and also a show cause. For arraignment, have you had a chance to review the charging document?
Yes, Your Honor. My client is aware of her charges and we wish to waive the reading.
How she was to plead to the charge?
She's going to stand mute at this time.
Under a plea of not guilty on the charge of operating while intoxicated, third offense. And does a forensic center referral requested?
It is not, Your Honor.
May I link the trial?
One day.
A docket call April 7th at 10:10.
Your Honor, could we have the, my client has court in another court on that day.
What court? Ohio Circuit or District?
District,
What's it for?
same thing.
Your Honor, I believe this is going to be resolved with a plea and because my client is currently participating in the sobriety recovery court in Alpena. And so I believe it will be resolved by plea.
She's in the Alpena sobriety court?
She's participating in it, yes, Your Honor. And that took place, her getting into it as this case had already been started and going through the system. And I believe I've been working with the prosecutor to get her into that program, and that's most likely going to be a resolution in this case.
Well, before I set the date, then let's go over the show cause and see what's going on here. We also have a show cause, Mr. Krajewski. It's alleged that you're in contempt of court for violating the conditions of your bond by testing positive for alcohol. So on the sober list on February 24th. You've got the right to have a hearing on those allegations where they would need to be proven beyond a reasonable doubt. You have the right to the assistance of your lawyer at that hearing. And to present evidence in your own defense and questioning the witnesses presented against you. If I find you to be in contempt, I could revoke your bond if you're not complying with bond, or I could sentence you to up to 93 days jail and or a $7,500 fine. Do you understand the rights you have and the penalty you could face?
Yes, Your Honor.
Mr. Gilbert, you know how she wishes to proceed.
Yes, Your Honor, we're going to request a hearing at this time. I did have some evidence that I've already presented to the prosecutor, and that will probably present an explanation what happened that day, an actually legitimate explanation.
So, Mr. McLennan, are you in this case?
Your Honor, that would be me.
So what can you tell me about pending charges she's got in the timeline?
Your Honor, the timeline, as I understand it, we got the third over there, and then we got our.
Hang on, you guys know a lot more about this than I do, so the third over there doesn't bring me up.
Third drug driving, Your Honor.
Out of what, but over there?
Otsego, I believe it is.
Mayo's not an Otsego or, I'm hearing Mayo, Otsego, Alpena. I'm hearing a lot of places and a lot of things, so I want somebody to kind of bring me up to speed.
So the courthouse in Mayo. Because the case is pending, your case is pending.
That's Otsego, isn't it?
My apologies, Your Honor.
So Oscoda County, there was an OWI third. What was the offense date on that? Does anybody know?
November 27th, Your Honor.
Okay. And that's still pending in the district court?
I just, it just got transferred over not too long ago. I just had my first district court,
What do you mean transfer?
What? Because I was in circuit court over there, and then it got,
Oh, and then it
like
went back,
this one,
it got
over to
remanded to
district court.
district court
and I went there last Monday, and they're putting me through the drug court.
in Alpena.
In Alpena, yes. So my sentencing for that to finalize the plea and everything is April 7th. To sentence me to drug court, my fines and stuff.
So on April, you already pled over there?
According to my lawyer, the last thing we have, I just sit there, my lawyer does all the talking, but as far as I understand that on April 7th is when the prosecutor and sentencing, I guess, it's already pled out for drug court. And
Did you enter a plea of guilty over there?
Did you admit to, in that court, did you admit that you were in that case?
I think so, yeah.
Did you tell the judge that you had been doing that?
No, I just go, my lawyer does all the, I just say, yes, Your Honor. I don't. The
You
judge is.
don't know whether you entered a guilty plea or not.
I think that's what it is. I just signed some papers, to be honest with you. I go by what my lawyer said, but they said sentencing was April 7th.
All right, and that's gonna be to the Alpena Sobriety Court, which is that a misdemeanor or a felony court?
I believe that is the felony court, Your Honor.
Your Honor, I do believe, just based off of working with Alpena, I believe the sobriety court is in the district court.
Yeah, I mean, they've got a drug court program, but I don't know if they have a sobriety court.
That is the drug court. That's what I'm doing.
Well, I'm a little less confused, but I'm not a lot less confused. Still moderately confused here about what's happening over there. What time is your sentencing in Oscoda?
I do believe it's 10:15.
Have you already started the Alpena Sobriety Court requirements?
Yeah, I have, I just talked to Nicole Hesh on Friday. Yeah, she called me on Friday, and I have to meet with the, one gentleman, she didn't tell me his name, this Friday coming up to get the finalization. But I've been doing the therapy sessions and, those steps up until because this gentleman's only in Alpena on Fridays. And then that's when I will start going in front of the judge every week and my home inspections and all that stuff. My community service and.
All right, well, I'll schedule this for a docket call in the bond violation hearing on May 5.
You know, that guy that they didn't tell her his name, which I'm sure they did, kind of sounds like a probation officer, maybe. Doing home visits and, you know, making sure she does her community service and everything like that. Yeah, that sounds like a probation officer kind of role.
At 9:30 a.m. You'll have to be here in person.
Yes, sir.
And by then we'll know what's going on with the Oscoda case and whether you're.
Would it help?
Alpena. and you still are on the sober link here. Guess what I'll tell you is what you got going on with all this drunk driving stuff. I'm gonna take at face value that Mr. Gilbert's got some information that is a legitimate explanation for these low-level readings on February 24th. But what I'm telling you is if I get indication where I think you're drinking, I'll have you arrested
Yes, sir.
and you'll sit in jail until May 5th to see me again.
Yes,
I will
sir.
not have you out there with all these drunk drivings, consuming a drop, not a drop.
Yes, Your Honor.
You understand me?
Yes, sir.
If you drink a drop and I find out, you will be locked up until May 5th.
Yes, Your Honor.
I'll see you then.
Thank you, Your Honor.
Your Honor, if I may,
Yes.
just in case the Alpena sobriety court can't take us on a felony, would we be able to submit a stipulation for remand? Recovery is the bullseye here, Your Honor. I'd hate to have us be later on that than we have to be.
Well, the charge is up to you guys. I mean, I don't know how many drunk driving she gets before she gets a felony, but that's on you guys. So if you want to resolve it by misdemeanor, I'll sign a stip to remand. But
Thank you, Your Honor.
I don't have to like it, but I don't have to.
Neither do we, Your Honor, but the goal is the goal.
All right, we'll see you then. All right, we're back on the record, the 53rd Circuit Court for the County of Presqu'île. As a reminder, we are providing public access both in the courtroom and also online. And we have next up, People v. Carter Bassett, file 24-93339FH for sentencing. Counsel, please state your appearances.
Zachary McLennan on behalf of the people.
Kristen Berg on behalf of Carter Bassett, who appears to my right.
Good morning. This is set for a misdemeanor sentencing on a charge of larceny over $200, a 1-year misdemeanor with a sentence agreement for a 6-month cap. There was no pre-sentence report done because it was a misdemeanor. There was an agreement for restitution to be paid in full at the time of sentencing. Is that taking place?
I believe Mr. Bassett is prepared to pay it. He has not yet, but he does.
Well,
have
let's
a
go off the record and go take care of that. So we're back on the record and recalling People v. Carter Bassett, 24-93339FH. And Ms. Burke, has restitution then been paid pursuant to the plea agreement?
Yes, Your Honor.
Okay, thank you. I did have a chance to review a written sentencing memo from the defense as well as several letters of support that were submitted for Mr. Bassett. And I did review a victim impact statement, 2 victim impact statements that were submitted in writing as well. So Ms. Burke, anything you want to say on behalf of your client?
Yes, just briefly, I think the sentencing memorandum lays out the most important details, but I strongly believe that Mr. Bassett has learned from this. I don't believe he will ever be before this court or any other court again. As you can see by the multiple letters of support, this incident is really outside of Mr. Bassett's character. And like I said, I don't think that he will be before any court again. I think he would comply with probation, and I would be asking for a sentence of probation, community service, and no upfront jail time. Thank you.
Thank you, Mr. Bassett. You don't have to tell me anything, and if you don't, I don't hold that against you in any way, but you are allowed to make a statement. Is there anything you want to tell me, sir?
Good morning. First off, last 10 months have really been hard, but it's also helped me refine myself and my business. Although this isn't the outcome that I would have liked for my remodel project, I'm glad we're able to fully pay back the original amount collective. My team was prepared to proceed and go through with the project. We applied for the permit. Although I did find out that the county building department had a glitch in their system, their online system, but they did confirm that they did receive my emails and the application. So, you know, we order material, including the specialty flooring, even had a start date. Unfortunately, I was unable to move forward with the project because the contract was terminated before the start date, and a handyman was hired in order to complete the project. Overall, it was never my intention to abandon the project or the client. And overall, I am pleased and glad that we're able to fully repay the deposit.
That's all?
Yes, sir.
Okay, thanks. Fine. You ready to take
Honor.
action?
I would begin by saying I've personally spoken to the victim in this case on more than one occasion. And it's very apparent, the emotional impact that this has had on her is tremendous. This is a life-altering occurred, and it's had a major impact on her family, and I think it in her letter to the court that's been received. So it's not just the victim, it's her whole family that's been affected by this. Currently, the victim has a home that it's still woefully inadequate. There's extension cords running through the home to supply power to various areas of the home. That includes from the living room to the bathroom. There's electrical wires hanging from the ceiling. There's missing drywall, there's missing insulation. And the victim's embarrassed to even have people over. It's just a terrible situation. And I did hear defense say this is outside of Mr. Bassett's character. It's my understanding that there's other factually similar matters either pending or being investigated on the other side of the state right now. And that is reflected in the police report. To add a little bit of information to what happened here, Mr. Bassett received a check on April 8th of last year for $70,000. And then April 10th of last year for $6,000 from Miss Roth to pay half of the amount for under the contract to get things going. So April 8th and April 10th, $76,000 from the victim to Mr. Bassett. These funds were initially deposited into another business account and then transferred to another account, the Northern Michigan Property Management's bank account. $76,000. Before these deposits, that balance in the bank account was $18,000. By April 11th, the bank account was down to $7,000. April 8th and 11th, withdrawals were made from that account to pay $35,000 plus to American Express. And then subsequently the IRS about $22,000. And I could kind of go on with that, but essentially large payments were being withdrawn from that account to pay credit cards and the IRS. I believe the victim was taken advantage of in this situation and left, as I said earlier, with a home that is just woefully inadequate. And it's not the home, it's the emotional impact this has had on her and her family. Your Honor, I think, again, there's been a tremendous benefit from this plea deal for defendant, but each and every day, those 6 months, I think is deserved. Thank you.
Thank you, Mr. Bassett. If you please stand for the court sentence. Bassett, this is strange. Somebody's phone is going off. Turn it off, please. It's a strange hearing to me because every once in a while, a defendant tries to do what you've done here. And that is, I want to enter a plea, but then I want to show up at sentencing and be sentenced as if I'm innocent and tell the judge how hard it's been on me. Mr. Bassett, that's a bad, bad plan. I can't take a plea and then treat you like you're not guilty, right?
Yes, sir.
So I got to sentence you as if you're guilty of the crime, larceny, stealing. It was pled down to a misdemeanor in exchange for your remorse, which I'm not entirely persuaded by your statement today. You know what I didn't hear? That's why I asked you. Is that it? What do you think was missing from your statement?
I'm sorry.
You still don't understand. You don't have any clue what's missing from what you said today? There's a lot of great people that wrote you letters. I have personal respect for some of the people that wrote letters on your behalf. They vouched for you as if you're not even guilty of this. So again, those letters are, I can't imagine he's guilty. Well, guess what? Mr. Bassett is guilty. He took a plea and he's being sentenced today. Plus, did you hear those facts? I mean, this isn't, gee, the project didn't go as I planned. This woman gave you $76,000 and you spent it on other stuff. Isn't that true?
Yes, sir.
Okay. What I missed from your statement was any compassion, understanding, concern, or even awareness of the fact, the impact that it had on her. Did you read the victim impact statements?
Your Honor, I don't believe we received them.
We're going to go off the record. I want Mr. Bassett to read. Off the record, you're going to read those and then I'll come back. All right, we're back on the record and Mr. Bassett has had a chance to review the victim impact statements. I want to say just a couple things about that. You're not responsible for a lot of the other bad things that were going on in that victim's life. I totally understand that. I wanted you to read that though, so that you understand why it is that we should move through this world and with kindness toward others and not stealing from others, because we don't know what they're going through. And so I hope that made some impact on you today. It's not your fault. Some of the other things that were going on in that victim's life, you didn't do those things, but that she had stuff going on in her life that by you then stealing from her made her feel unsafe and victimized in the one place that she came to feel safe. So when we victimize people, we compound problem upon problem. You don't know what's going on with somebody's life when you encounter them. And Mr. Bassett, your lack of understanding that you've done wrong is surprising to me today.
You can't teach compassion. Not after like 4 years old. Someone who has no empathy for others, they're just hollow. They're empty. You can't make them any different. Mr. Bassett is one of those people. He's all about himself. He doesn't have a lick of compassion in him. So sadly, the judge's words are falling on deaf ears.
All these letters that say, you know, that you've got great character and this is so outside of that. You clearly are surrounded by lots of high caliber people. It's not very often I get a list of letters that good from people of that caliber. But I want to tell you something, Mr. Bassett. Your character is formed by what you do.
Yes, sir.
And you stole money from somebody. And as you stand here today, I don't even know if you believe that. I don't know if you think you stole from her, because all the stuff you told me today was self-justification. But what I heard from the prosecutor was you took somebody's money to set aside for their project, and you spent it on stuff not for her project. That's stealing. That is forming your character. That means how many thefts must you commit before you're a thief? Maybe one. So Mr. Bassett, by your choices, you have formed the character of a thief. That does not mean that you have to retain that character. Your story is still being written, and guess who writes it? You do. You write it by the choices that you make. You might think I've been overly harsh in my comments to you today, I perceive that to be a necessary corrective to some of the enabling from the very good people around you who I'm sure are acting from the best of intentions. But you need some tough statements into your life, Mr. Bassett, so you don't steal from people anymore. This was felony conduct. Because you were willing to make restitution, that's a big deal. That's a good thing. And you've done that today. That's why you got a misdemeanor. It's punishable by up to a year in the jail. I would give you that full year, but for the sentence agreement that caps it at 6 months. It is the sentence of the court that you do 6 months in the Presque County Jail forthwith. There's state costs of $50, crime victims assessment of $75, court costs of $350. Were you arrested on this charge?
Yes, sir.
And how did you bond out that day or the next
Yes,
day?
sir.
That very day? Did you
Yes,
do
sir.
it? Did you do an overnight?
No, I spent a few hours.
Okay, so credit for 1 day served. And you can file an appeal if you wish to the Court of Appeals, that'd be by an application. If you wanted a lawyer appointed, you'd have to make that request within 6 months. We're gonna hand you a copy of that appeal paperwork and ask you to initial one copy for us. The other one is for you to fill out if you want to take an appeal. I'm not gonna place you on probation, so when you're done with your time, you go on with your life. And I expect that you're gonna do some very good things with your life, Mr. Bassett, and draw all the right lessons from this. One of them is you have to be responsible for your choices. All right, we'll be in recess.
Mr. Bassett is a lost cause, in my opinion. I wish they could have given him that full year. Yeah. Yup. I'm glad I'm not alone in this opinion, you know? I know I'm a bit judgy sometimes, but yeah. All right, now let me put on tonight's docket.
Are you there?
Yes.
Okay.
I agree with you that, and here's what I am because, listen.
This is a citation. It was issued on February 15th of this year on 142nd Avenue there in Door Township, improper lane use. Mr. Meyer, you're here on this citation to do one of three things. First is you could admit responsibility to the citation, or two, admit responsibility. Excuse me?
Am I allowed to talk to the officer privately or no?
Well, we would have done that before today. This is the informal hearing. Or two, you can admit responsibility and provide some sort of explanation as to how or why this happened. Or three, you could contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
I'm contesting it. I'm fighting it.
All right. Then the first thing I'm going to do is have you both raise your right hands. Do you swear or affirm any testimony that you give here today would be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor. Yes, I do.
All right. Mr. Meyer, it makes a lot more sense for me to start with the deputy. He has the burden to establish to me why you were issued a citation in the first place. But then after that, you'll have an opportunity to either ask questions or testify in your own behalf. All right. And with that, deputy, you want to pick up the narrative somewhere where it makes sense, explain the issuing of this citation.
Yes, February 15th, approximately 2:47 in the afternoon. I was on routine patrol in Door Township on 142nd Avenue, traveling westbound. Just to give you a little bit of update on the surrounding area. Eastbound and westbound, single lane with a left turn lane in the median. I observed a Honda sedan traveling eastbound on 142nd, traveling behind three vehicles. The front vehicle was making a right turn, and the vehicles behind the vehicle making the right turn came to a stop in the roadway. The gray Honda sedan began to make a pass in the left turn lane, passing 3 vehicles at once and getting back into the eastbound lane after moving out of the left turn lane. I initiated a traffic stop due to the hazardous pass and advised on the issue. Subject admitted the pass as he drives for a living and he drives for, I think it was Uber or one of those eating apps. And he was on his way for a delivery and didn't understand the hazard of the pass. So I ended up giving the warning for the improper pass and issued a citation for the improper lane use.
All right. And Mr. Meyer, what is it you wish to tell me?
I was doing DoorDash. I just delivered into that area. It was a lot more safe to do what I did. I was driving behind them for a mile. So, and like he said, they were stopped on the road. I've driven for a living for a long time. I put, anywhere from 60 to 80,000 miles on my car. There was a car behind me. The only 3 accidents I've gotten in is somebody has rear-ended me. So I see people passing all the time. There was nobody. I mean, he also said he saw this stuff. He didn't see this stuff. There was nobody coming on oncoming traffic. So that's the reason why I got in the middle lane. That area does not have turn lanes. So I was driving behind this car for a long time. The speed limit's 45 there. They were going 25. So like I would agree to a ticket, but I'm not agreeing to a ticket that puts 2 points on my record. I drive for a living. People use that lane all the time to pass. You can say whatever.
Mr. Meyer, you did 2
want,
things wrong. That's an improper pass and it's unlawful lane use.
No, it's
if
not.
you'd like
People
one
do
of
that all
those
the
tickets
time.
more than the other one, I'll allow it to be amended to it. But you're definitely responsible for one, if not both, of those moving
They were
violations.
stopped on the road, like the guy said.
It doesn't matter, sir. The lane you use is improper, and it was an improper pass as well because you went into.
No, they were stopped on the road.
We're all set, sir. So I would find you responsible on this citation as it's written. Now, you do have a right, because you had a contested hearing, to say, hey, I don't agree with that. I want to go to what's called formal hearing in front of the district court judges with the prosecutor's office. To do that, you must do 2 things. One is you must ask for that within 7 days of today's date. Your window of opportunity on this closes after 7 days. And 2, you must come in and post a cash bond in the same amount as the fine to guarantee your appearance at formal hearing. Do you understand your rights?
Yes.
All right. And the deputy, you would certainly have the option to go ahead and write an additional citation if you thought it was merited. So we're all set for today, gentlemen.
Appreciate it.
Release you.
I think that's the judge begging the officer to please issue the other citation.
I'm not trying to argue in traffic.
Thank you.
You want to start?
Just get this done, this adjournment.
Sure, we can call me Megan.
I know, I was here first.
You were first.
I was here at 8 o'clock.
Morning, Your Honor. Today's the date time set for sentencing on file 24S31712FH and 24S71313FH, Zachary Allen McMeekin.
Is he at the jail?
He is in the jail.
We have McMeekin.
Yes, sir.
McMeekin. Come on.
Mr. McMeekin?
Yes, sir.
All right, what are we doing?
Your Honor, I'm asking for an adjournment. I don't think that we're prepared to proceed with sentencing. There's been an issue arose prior to the last sentencing with the recommendation. We had an agreement that my client would be screened for ARC and Swift Insure. There was an issue with the charging information.
So let's stop there. He was, it says right in the PSI.
Pardon me?
He was screened for those. It says so in the PSI.
That's correct. So the reason
He
that
had to
he
be
was,
assessed for Swift Insure and a long-term report.
and the reason that he was denied,
Was he assessed for both of those programs?
He was.
Okay. So he was denied.
he was denied because of the original charging information indicated that he was charged with delivery and manufacture, which according to the statute disqualifies him from Swift Insure. I had a discussion with Mr. Shields in his office, with Nakota, who runs the recovery programs. I asked them what we needed to do to remedy this, and I was assured that if the felony information were to be amended and that that count was eliminated from the charging information by an amendment, that he would qualify for Swift Insure, and that I was assured that he would be entered into that program. I proceeded down to the prosecutor's office and I got that amended felony information and I filed it with the court.
I think I can expedite this for you.
Okay.
We adjourned this 2 weeks ago. I completely understand, regardless of whether there was some issue with the prior charging decision, whatever. And every time I review this, because it was adjourned 2 weeks ago, I want to make sure that I don't bore people, because your client is the guy, and I've got it all marked up here now. And again, looking at all this last night, he has had every opportunity under the sun to take advantage of programming. He's been, I don't want to get into it because I feel like I'll be sort of revealing the star of the show, but when I just look at 8 of 19, how a guy goes to prison, and Ms. Vanderbeek, I don't even talk to her about this, but he goes to prison, sentenced to 30 months back on July 27th of 2004 via plea. And then he's paroled January 19th of 05. So he was there a grand total of 4 months.
That's an insult to the victims.
And then he gets paroled and sent back to prison 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 times. It's unbelievable. I don't know that I've ever seen a case before, and there's no way that your client with a straight face could argue that he hasn't had the opportunity to take advantage of programming. I mean, there's just no way. So I have zero interest in putting your client in any sort of special court. Like, I would not do that. And I'm ready to explain that at length whenever we get to sentencing. Now, if you need 2 weeks, that's fine. You can adjourn it 2 weeks. But he's just not an individual that should be granted yet again another opportunity, most importantly, to victimize the community. Because when I see a Department of Corrections that puts somebody in to prison 30 months and he gets out 4 months later, so it must have been boot camp, is what I'm guessing. So, and that's just what, 8 or 9, whatever the number was. Then he goes back to prison again and he gets paroled multiple times. And yet every time he re-victimizes the community. And at some point we have to stop. We can't keep exposing the community to your client. I hope that he's sincere. I read what he said, but you are what your record says you are until proven otherwise. And once he gets out of prison, he can do all the things he's expressed in this PSI. He wants to get help. He wants to turn his life around, and he could take advantage of all the resources that has previously been offered to him by the Department of Corrections at least a dozen times. And that's kind of how I view it.
I sincerely appreciate the court's explanation and giving us some heads up and direction in that. May I inquire with the court?
Yeah.
For
for clarity or for hypothetical purposes, if the PSI today in front of you for sentencing recommended Swift Insure,
I would not have given him.
you would not give him Swift Insure. So even if I'm successful in convincing the probation and parole department to change their recommendation,
I would not allow Swift Insure, and here's why. There are certain individuals, he would be one, I think we could all say, he has failed miserably at supervision, whether that be probation or parole. But again, when I go back to, and I was just reading one of the entries, I'll get to the other one. This guy has been paroled more than a dozen times. I mean, I didn't add them all up, but just 10 on the one case. Now, if I go to 15 to 19, returned to prison 3 more times there. I just have never seen anything like it. I just can't. And then 16 of 19 returned. Swift Insure as an alternative to prison. Certainly your client would fall within that prism, if you will, of should there be an alternative to prison? He would be eligible for it, but should he? The answer to that is absolutely not. I mean, you should only get so many times in life to victimize the community, and your client is just, well, he has 4 prior felonies, 14 prior misdemeanors, and his use of the community, meaning the state, local communities, resources throughout his criminal career, if I can put it that way, is unbelievable. I can't see allowing him yet another opportunity to victimize the community and just suck up these resources when his record shows what he is. I hope he changes.
I appreciate that, all, Your Honor, and I just want to put on the record the reason why I'm asking for the 2-week adjournment is because when I thought that I did what was requested from Circuit Court Probation to correct the charging information, I had that conversation on March 4th with Mr. Shields and Ms. Nakota, I think it's Howe, in his office. I talked to office staff in the front of the office. And on March 4th, I went to the prosecuting attorney. We had a negotiation. We had a discussion about the matter. We had a discussion about the legitimacy of that original charge, which would disqualify him from Swift Insure. And the decision was made to amend the charging information. I personally took the amended original and filed it myself on that day. And I delivered a true copy to the probation department. And I was told that, well, this will be easy because we won't have to change very much with the PSI, but this will be an easy PSI revision to make. I was expecting a revised PSI. I never got one, and I'm not faulting or complaining about that. Sometimes we don't get the PSIs until the day of sentencing. So I totally expected a revised PSI today. I was relying on the fact that my client was going to be accepted into Swift Insure, and I needed some time to explain to him. But I appreciate your guidance and your explanation and rationale.
Let me ask, so you said you were expecting a revised PSI to say what specific?
That the department that he qualified for Swift Insure, and that was going to be the recommendation.
You're not, well, hold on. You're not suggesting that he is not eligible for Swift Insure, right? I didn't read that in the PSI.
I don't know that he is. However, I wasn't part of the discussions that he's talking about.
Mr. Shields, maybe.
He's otherwise eligible, correct?
Yes, he is eligible
All right.
for Swift Insure upon dismissal of that charge.
And is that all you're looking for, is something that says he would otherwise be eligible?
I was relying on that, yes, and also that he was going to be recommended for it. And I came here today prepared to have that recommendation. Now, if the court took their recommendation and disregarded it.
I guess I'm confused. How did we get to the understanding that it was going to be recommended?
The only issue that we had with him not being recommended for the program, not just disqualified,
The charging.
was the charging document. And I had assurances from Mr. Shields that he qualified and it would not be a problem. And I didn't realize that the recommendation wasn't going to change.
So let me just ask, so did you two ever have a conversation that would suggest that he was being recommended for Swift Insure?
Your Honor, we can't recommend anybody into the program. We can only suggest they qualify. And then it's up to the courts to determine whether they want to put them in.
All right, so I don't have any objection. You need to do your job. If you want to adjourn in 2 weeks, that's fine. I don't mind even, we'll add some language
I can do a case report.
that he is otherwise eligible. And then if probation feels strongly about it, certainly you can, because that's your job, and you want to try to persuade the court, I'm always willing to listen. I'm always going to have an open mind, but keep in mind, I don't want to mislead anybody, particularly your client. I like to start at the middle of the guidelines. I often believe that to do this job appropriately, when you have all this information at hand and you review that and you think about it, if you walk out here and allow yourself to be persuaded from a range, then I don't feel like you're doing your job, right? Because then we end up ignoring the things that matter, like prior criminal history, offense variables, the guidelines. So listen, if there's some argument that says all of the things that I've noted, and that's the bulk of them, that whatever is going to be argued in 2 weeks is that much greater, outweighs all of those things that we have just discussed briefly, well then sure, let's consider it. But I just, even keeping my mind as open as I can, I can't see the raw numbers, the record overcoming that. We'll adjourn 2 weeks. We'll see you in 2 weeks.
Thank you, Your Honor.
The judge is saving himself from being accused of bias or being accused of, predetermining this guy's sentence or future. Yeah, at least the judge is honest about it. The guy doesn't deserve it. He's been let out and put back in so many times. He doesn't deserve it.
Yeah.
We have Hunter Jones at the jail, please.
Yes, ma'am.
Thank you.
For the record,
I'm watching.
this is People versus Hunter Shea Jones, file number 25S32059. Sorry, H. It's set for sentencing and a PD status.
All right, Ms. Lyons, if you have an adequate, if there's a PD, I only have one file.
It's not a, he needs a bond.
Okay, all right.
Oh,
Sorry.
If you had an adequate opportunity to review the pre-sentence report and the sentencing information with your client,
I have, Your Honor.
additions, corrections, or deletions.
No, Your Honor, not at this time.
All right. Are you Mr. Jones?
Yes, sir.
All right, and does your client have any objection to being sentenced remotely?
No, Your Honor.
All right. Anything on behalf of the people?
Judge, we would ask that you follow the recommendation.
Okay, Ms. Lyons.
Judge, also asking that you follow the recommendation as well here. I would note the recommendation, as the court understands, is for 10 months in the Montcalm County Jail. Reasons to consider following this recommendation would include, when I look at the underlying offense, while I certainly recognize my client was in possession of double-edged knives in the stop, it doesn't appear as though he was intending on using those for any type of nefarious purpose or to somehow engage in threatening behavior. He just simply had those in his possession and was transporting those items. I'd ask the court here to consider, if the court would consider allowing him to serve all or even a portion of his jail time on house arrest, he would be very grateful. He assists with his 78-year-old grandmother, who I think is, he reports is not in the best of health. So he's asking the court to consider that here today. If the court is inclined to do something other than the recommendation here, there are programs available to my client, alternative directions and things of that nature have been successful. I think that certainly he's could be a candidate for something in that realm, but ultimately we believe that the recommendation here is appropriate.
So I just want to confirm there was no agreement that he could come over, right?
That is accurate, Your Honor.
And I was just totaling that up here. I'm guessing this was not your recommendation, so I won't even ask. But it looks like he has had 1, 2, 3, 4. 5, 6, 7, 8 previous jail sentences. And 2, 3 prior opportunities at probation. So I'm struggling to follow why a new probation jail sentence is going to change anything.
Judge, while I understand the concern there, I know in speaking with my client, he has indicated to me, despite the fact that we're asking for the recommendation here, we would offer instead for the court to consider allowing him to be on probation, effectively with the notion or the idea that if he is unsuccessful, he would then ship to a DOC sentence. That would at least afford him an opportunity to heed the court's warning in this particular instance. If the court is insistent that a DOC sentence is warranted, I would ask the court to consider even sentencing in conjunction with DOC, things like, for example, boot camp. I think that my client would be a great candidate for, and I think that ultimately could benefit him, particularly as it relates to having struggled in the past with probation. So these are things that I'd like the court to consider in lieu of a straight DOC.
So there's no doubt that I would consider boot camp, but let's first hear Mr. Jones. What do you want to say, if anything, before sentencing?
The only thing I really have to say on my behalf is that I've been trying. I mean, I haven't had much time to prove myself. I've been trying to do better in the community. Like when I got out from my last charge or whatever you call it, last sentence, I ended up getting a job at Die Castle and working for about 2 or 3 months. And while I was working and helping my grandmother out because she's 78. She can't even sleep in like a bed anymore. She has to sit in a chair to sleep because everything's getting to her. Her back's all messed up. And I've been trying to help her at home during all this situation and clutter. And I'm like, that's where my biggest focus has been lately. Like I even like when I was on PR bond, yes, I understand I dropped dirty, but I was at home most of the time and I was doing what I needed to do while I was on PR bond other than the dirty drops. Sir, I'm not trying to say that them were right. I'm trying to say that I was trying to do what I could to better myself instead of just continuing to go out and cause a ruckus or a mess, because I've caused a mess and a ruckus in my life, and I'm not trying to continue that. I'm trying to better what I have left of my life.
So he raised an important point. We didn't even address the bond violations yet, which is something that we need to talk about also. What's your client want to do with those today?
My understanding is he's prepared to admit those violations, Your Honor.
All right, so let's have him sworn. You raise your right hand. You solemnly swear a firm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can put your hand down. So, Mr. Jones, you understand as it relates to bond violations, you do have a right to have a hearing. Are you waiving your right to have a hearing?
Yes, Your Honor.
All right, and do you understand that when you waive your right, well, let's back up, something we didn't cover. The bond violations are contempt of court, and they're punishable by up to 93 days in jail. Do you understand that?
Yes, Your Honor.
All right, does that change anything for you?
No, Your Honor.
Okay. Does it change anything for you that the 93 days can be a separate sentence from the one that you're here for today? Meaning the court doesn't have to impose those and run them concurrently. Do you understand that?
Yes, Your Honor.
Okay. You still want to go forward with a plea?
Yes, Your Honor.
Okay. Now, if you want to do that, if you're going to waive your right to have that hearing that we just talked about, then I have to describe for you all the rights that you have at a hearing. So bear with me. At a hearing, you'd have the right to be presumed innocent of the bond violations. At a hearing, you'd have the right to confront witnesses called against you or to call your own witnesses. At a hearing, you would have the right to testify or not to say anything, and the trier of fact couldn't use that against you. At a hearing, you'd have the right to the assistance of an attorney because of that jail component. And you have Ms. Lyons, she can stay with you throughout a hearing if that's what you wanted to do. Are you waiving all those rights that would come with a hearing?
Yes, Your Honor.
Okay, as it relates to the bond violation, has anybody promised you or threatened you or done anything to you to get you to enter this plea?
No, Your Honor.
All right, as it relates to the bond violation, has anyone besides Ms. Lyons, because that's her role, if you will, as your attorney, has anyone else said anything to you about what your sentence might be as a result of entering this plea?
No, Your Honor.
All right. Let's talk about those violations then. How do you plead to the allegation that you violated the terms of your bond on or about February 4 of 2025 when you tested positive for methamphetamine and THC?
Guilty.
Okay, and this is not trying to trick you, but in your own words, what happened?
I dropped dirty at the drop site that I was given to go to for methamphetamine and THC.
All right, and so for purposes of the plea then, do you acknowledge that it was condition of your supervision, your bond, if you will, that you could not use any controlled substances?
Yes, Your Honor.
All right, and then do you also acknowledge that on or about February 4th of 2025, you actually were on bond for this underlying charge, is that right?
Yes, Your Honor.
Okay. Court will accept your plea on a factual basis. Now, I would note it says that he violated 3 times, but that's the only allegation I'm finding in the file.
I don't have any control over that.
Okay.
That's the only thing I'm aware of, Your Honor.
All
is
right.
the-
Well, the PSI says that there's 3 positive tests.
There should be 3 different dates that he gave
Yeah.
positive tests and the community corrections report.
I don't have their report. So here's what I'm gonna suggest. Oh, attached to the PSI.
Yeah, it should be. Oh, no, it's not.
Yeah, I'm not seeing it, but here's what I would suggest. I've already found a plea here. Does anybody have any objection to dismissing the other 2 violations?
No, Your Honor.
All right, then we'll go ahead and do that. And then we can proceed to sentencing now on both cases. Court's already provided allocution to people, defense counsel and Mr. Jones as it relates to the underlying offense here. Mr. Jones, is there anything you want to say about the contempt? And Mr. Jones, before I impose a sentence on both of them, I just want to pose something to you. I've already noted that, well, I didn't note this. You're 23, so you're a pretty young guy. What do you think about staying locally? It doesn't seem to make sense to the court because, as I mentioned, you've been given jail sentences multiple times, probation multiple times, and it hasn't seemed to work.
I think it would be more of a privilege to stay locally because, I mean, yes, it hasn't worked before, but now I'm willing to give it a chance in my own way instead of just fighting it. And I'm not trying to keep fighting it. I'm trying to do better. And my grandmother's dying, and that's more of why I'm trying to stay local. I'm not trying to let her die in front of me and not be able to say goodbye.
All right. Sometimes loved ones can be a strong motivation, but I don't find in general the court's experience that that is a lasting motivation, right? Unfortunately, things happen, we get upset with one another. You know, even worst case, grandma passes away, and then that sort of motivation that you might have now fades with time. And this is a weapons case, but as I look through here, I think a lot of your problems involve alcohol and drugs. I'm going to impose a sentence here that I honestly don't believe has much chance of succeeding. But I'm also trying to take into consideration everything in the PSI. Part of what's in the PSI we haven't even discussed is it's not often that a 23-year-old we encounter, he's here partly because you were hanging out with your mom. And your mom is driving the vehicle that you're a passenger in, and mom has meth and a warrant. So that's sort of the, you know, when we're raised by wolves, I guess we can't expect the pups to be much different than the wolves that are raising them. However, at some point, you got to either choose to live a different type of lifestyle and or suffer the consequences, I suppose. Here's what I'm going to do, Mr. Jones. I am going to follow this recommendation, okay? But I'm going to do it in a manner that I think will ensure that when you are released from jail, we're giving you the best opportunity to succeed, because you're going to have a nice long time without any substance abuse use, okay? So I'm going to first sentence you on the contempt of court. The contempt of court's going to impose 93 days in jail. They're not going to impose any monetary obligations. And there's no credit for the time that you've served on the contempt. Now, you do receive credit on the underlying charge that I'm going to address right now. The underlying charge, before I get to a sentencer, I do have to impose a $130 crime victims assessment. I do have to impose a $500 fine. Well, the court is going to impose. That's not required by statute. That's a crime victims assessment. There'll be $550 court costs and fees, and then $68 state costs required by statute. I'm also going to place you on a period of supervision for 2 years, okay? That period of supervision is going to include all the standard terms of supervision. I'd like to have a substance abuse assessment done so that we can follow the recommendations of that assessment. I'd also like a mental health evaluation, where I look at all the other issues in this PSI, some of the diagnoses that you've had in the past, those types of things, and then we can follow the recommendations of that mental health assessment. And I'm assuming we can get all this done before he's released. But there's certainly much in this PSI that would suggest that getting those done together and following the recommendations hopefully would be helpful. While you're being supervised, Mr. Jones, you'll have a curfew between the hours of 10 p.m. and 6 a.m. I'm going to require that you maintain employment. I don't know that we've been very successful with that, of at least 30 hours a week or a combination of it with your supervision obligations. It just escapes me our standard terms that I wanted to highlight. Oh, COG, I think COG, while you're in the jail, will be useful and helpful. And then Ms. Vanderveen, because I don't have it in front of me, I have like all the standard terms of supervision.
Supervision fees.
What's that?
Supervision.
Yeah, supervision fees are $30 per month while you're being supervised. Now, as it relates to the sentence for this case, the weapons case, oh, also we have to order forfeiture of the knives. That's by statute, I believe. as it relates to this case, court's gonna impose 9 months in the Montcalm County Jail. But that will not run consecutive with the contempt. That's going to run, you'll begin that sentence after serving the 93 days on contempt. Then you'll start the 9 months on the sentence. Yeah. Yes, will be. I meant it will not be concurrent. You're right. It will be consecutive. You'll begin the sentence after completing the contempt. And if you're doing the math, that means you'll be there for a year, but it's an alternative to prison. Okay, and hopefully we'll have some programming done before you're released. And if everything that you've indicated to the court is sincere, you should be able to step out of that jail on the right foot, so to speak. Okay, so 1 year and then credit for 36 days on this underlying file. 1 year credit for 36 days. Now, as it relates to both of these sentences, Mr. Jones, you do have a right to seek appellate review. If you'd like to do that, you have 21 days from today's date to make that request. Want a court-appointed attorney to assist you, you have a broader window of 42 days. So 21 and 42. Ms. Vanderveen, did I miss anything?
You just stated 1 year with credit for 30 days.
I'm sorry, 9 months is what I was saying. 9 months with credit for 36. I wanted a year is sort of the total in my mind. Anything else? Ms. Lyons, anything else?
I don't believe so, Your Honor.
Okay, so if you'll fill out that appellate paperwork, Ms. Lyons is going to make sure we get it back in the file. And then if there's nothing else, I'll conclude the matter. Mr. Jones, good luck to you, all right?
Thank you, Your Honor.
Thank you, Your Honor. Up to you. No, sir.
Thank you.
All right, we are next taking up this case of People of the State of Michigan versus Jennifer Arletta Ronk. This is case number 23-13522FH. Joining me today via Zoom from the Wexford County Jail is the defendant, Miss Jennifer Arletta Ronk. Miss Ronk, are you able to see and hear the court, ma'am?
Yes, sir.
Thank you. Also here before the court is Mr. Kevin Stapleton, an agent from the Michigan Department of Corrections who is serving as the probation officer on this file. Ms. Ronk, I'm here to go over an arraignment on a request and warrant for a probation violation. I need to tell you what the charges are, what your rights are, and your possible consequences. This request and warrant was presented to me earlier this morning. It was originally signed by Mr. Stapleton on March 7th. And I signed it this morning, today on March 10th. It alleges that you have violated the terms and conditions of your probation in 3 ways. Count 1 is that you allegedly violated condition 2.4 that requires that you must not use or possess controlled substance or drug paraphernalia. And more specifically, it's alleged that on or about March 7th of 2025, you possessed a pipe commonly used for smoking methamphetamine.
No.
Hold on, and Ms. Ronk, let me just tell you what the Let me just tell you what the allegations are first. Then I will turn to you and we'll talk. So just let me, I have to get through telling you what the allegations say first. Count 2 alleges that you violated condition 2.0 that requires that you must not use or possess alcoholic beverages or other intoxicants. And more specifically, it's alleged that on or about March 7th of 2025, you possessed alcohol. Count 3 alleges another violation of condition 2.4, which again requires that you must not use or possess any controlled substances. And more specifically, it's alleged that on or about March 7th of 2025, you used methamphetamine. Was that the result of a drug test, Mr. Stapleton?
Yes, it was.
All right. Now, Ms. Ronk, you have the right to challenge these 3 allegations at a contested hearing. That hearing would occur within 14 days from today's date. At that hearing, you would have the right to have the prosecutor prove the allegations by a preponderance of the evidence. Additionally, you'd have the right to review any evidence presented against you, as well as the right to question and cross-examine any witnesses presented against you. You also would have the right to present witnesses, evidence, or testimony if you chose to do so. You also would have the right to be, the right to remain silent and the right to not have its silence used against you. And you also would have the right to be represented by an attorney at that hearing and all subsequent proceedings. And if you cannot afford an attorney, the court will refer the matter to the Wexford Misaki Public Defender Program for the appointment of an attorney. Now, if you're found to be in violation of your terms and conditions of probation, you would be resentenced on your original offense. You were originally convicted in this case of possession of a controlled substance, methamphetamine. That is a felony punishable by up to 10 years and or up to $15,000. One moment. In this case, you were originally sentenced to 365 days of jail. That was issued on July 24th of 2023. Now that I'm sorry, and these are 3 technical allegations, which means if found guilty of all 3, the court could sentence you only up to, or add to your sentence up to 45 days. Now that I've told you what the allegations are, what your rights are, and your possible consequences, I need to see how do you wish to respond. The first question is, do you need the court to appoint an attorney to assist you?
Can I say something, Your Honor?
Well, I'm very concerned that if
Please?
you do, well, hold on, let me just say something first. I just want to remind you that I'm not going to ask you any questions, and any statement that you choose on your own to make could be used against you. Now, I don't know what you're going to say, but you've only asked me permission to speak. You may speak.
Your Honor, that alcohol bottle that Mr. Stapleton found is the alcohol bottle that was my mom's. I had it sitting on my dresser. That wasn't, I don't drink. It was my mother's before my mom passed away, and I tried to tell him that.
All right. And when was it that your mother passed away, Ms. Ron?
2022, or no, wait, 2021.
Well, I just
I've
asked
had
that.
that alcohol bottle ever since.
All right. I'm very sorry for your loss, and I understand how those losses can continue to stay with the person. All right, so clearly, your request is to enter a not guilty plea on your behalf. The court will do so.
I don't want to I want to enter a guilty plea. I just wanted to let the court know that that was what that alcohol bottle was, and I don't deserve to be in trouble for that.
Okay, well, hold on, Ms. Runk. I need to go back and explain something, and that's all right. First, again, I remind you that you do have the right to have an attorney appointed to assist you if you choose to ask for one. Now, the question here is first, if you want an attorney, and then if you tell me you don't, then I can ask, do you wish to have it set for a contested hearing, or do you choose to plead guilty? Now, if
I
you
plead
choose
guilty.
let me get through everything to make sure I do it appropriately for you. If you do plead guilty, I'm going to ask, are you going to plead guilty to all 3? Now, if you do plead guilty, you'll be giving up that right to have that contested hearing, the right to have an attorney appointed to assist you, and that attorney could help you both at the plea, making a decision about what to do, review the evidence, negotiate the case with the prosecutor, and represent you through the hearing and sentencing. But again, if you choose to represent yourself, the Constitution does allow you to do so. Now, if you plead guilty, if you don't plead guilty to every charge, then the prosecution and the Department of Corrections can still have a hearing on that other charge. So for instance, if you do not plead guilty to, say, the alcohol charge, then they have the right to continue. In which instance, if you wanted an attorney to assist you, I would make sure that you got one. Now, by the way, having an attorney appointed is not going to make anything go faster or slower. we would most likely be back on the record, I think probably tomorrow, maybe Wednesday, because I do not have any trials this week, which means it's not going to delay the case if you ask me to give you a lawyer. I'm just going to go back again and ask you one more time. Do you wish for me to refer the matter for the appointment of an attorney?
No, I know I've been bad. I did good for the whole year, so I know I deserve it.
Well, let's do this,
I
Ms.
swear.
Ronk. Okay, hold
I
on.
plead guilty.
Okay, hold on. I'll get you there, Ms. Ronk. Please raise your right hand if you would, please. Thank you. Jennifer, do you hereby swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may lower your hand. Now, Ms. Ronk, again, you understand that you have the right to have an attorney appointed to assist you or the right to hire your own attorney. Do you understand that?
I do.
And do you understand that you have the right to have a contested hearing and make the prosecutor come in and conduct a hearing and prove guilt by beyond a preponderance of the evidence? Do you understand?
I do.
Has anyone made any promises, threats, or inducements to force or compel you to plead guilty to these charges?
No.
Has anyone, and sometimes people will talk to their probation officer, and that probation officer may suggest what he or she might ask for, but has there been any promise to you as to exactly what the sentence would be if you pled guilty?
No.
And are you waiving your right to a counsel today of your own free will?
Yes.
Are you waiving your right to a contested hearing also of your own free will?
Yes.
As to the 3 counts, Ms. Ronk, how do you plead?
Guilty.
No, wait, hold on. Ms. Ronk, hold on. I did say hold on before you stated your sentence. I'm sorry, your plea. Let me ask this question. Mr. Stapleton, how many days of credit does Ms. Ronk have?
Be 308 today.
Ms. Ronk, again, I stopped you before you entered that plea because something entered my mind. And I want to go back because I don't know what's going to happen or what my sentence would be. However, because you have already served 365 days, although you did, hold on. I sentenced you to 365 days. You served so far up to 308, which means you received all of your good conduct time, which would be up to 60 days, which means if I give you a sentence and I sentence you even to, well, hold on. I can't do that either because it's not, I can't send her to prison under 3rd technical.
No.
Yes. Hold on, Ms. Ronk. I need to take a look at a recently revised court rule. Oh, sorry for taking so long, but I want to make sure we get this right. And 7714B, 1 second. There we go. Yeah, all right, thank you. According to MCL 771.4B, parenthetical 4, the court cannot give a prison sentence after only 3 technicals. Actually, it says I can't terminate probation, but if you send somebody to prison, you're terminating probation. So, all right. She hasn't had any other PDs in this file?
Not in this file.
All right. Ms. Ronk, again, how to the 3 counts, how do you plead?
Guilty.
Or the court can accept your plea, I must take in some facts. Ms. Ronk, is it true that on or about March 7th, you were found, March 7th, 2025, you were found to be in possession of a pipe or paraphernalia commonly used for smoking methamphetamine?
Yes.
Is it also true that you tested positive on or about that date for the use of methamphetamine? Because you had
Yes.
previously used, okay? Because you had previously used some, is that correct?
I did, Your Honor.
All right. And is it true that you also were found to be in possession of some alcoholic beverages? I think you described it as a bottle of alcohol. What kind of alcohol was it?
It was a Tennessee Jack whiskey bottle that belonged to my mother. I really honestly didn't know I'd get in trouble for it because I haven't had it. I've had it and I've never gotten in trouble for it before.
All right, I don't know, but all I know is the court takes judicial notice of the terms and conditions of probation. Hold on. I'm taking judicial notice of the terms and conditions of probation that were signed by me on July 26th of 2023, and then acknowledged by the defendant on March 18th of 2024. I also find that the defendant's waiver of rights is made freely, knowingly, and voluntarily. The court further finds that the information provided by Ms. Ronk under oath on the record, in addition to the terms and conditions of probation taken notice of by this court, satisfy the required proof for counts 1, 2, and 3. Therefore, the defendant is found guilty of those 3 counts. Mr. Stapleton, do you want to make a oral, or would you like to add some? What would you like to do?
Oral would be,
All right.
would be appropriate, I believe, in this case.
Ms. Ronk, you have the right to be physically present here in this courtroom at any time you are sentenced. Do you wish to be here, or will you allow us to do sentencing right now with you appearing via Zoom?
You can do it right now, Your Honor.
Court takes notice that the report rules allowing video conferencing here are appropriate. Mr. Stapleton, you don't really need to say a whole lot since there's nothing I can really do, but go ahead.
Yes, Your Honor, this is a difficult situation. This is the defendant's first violation.
Right.
She really has done fairly well. I'll give her that for the last year.
I will say, Ms. Ronk, I was shocked to see your name this morning only because it reminded me that I hadn't seen you in a while, and I'm really glad to see that you've been doing well. Seriously. You know, for a while there, you were in and out a little bit, but it's been at least a year. Well, obviously it's been at least a year. So I compliment you on those positive progress.
So I don't think she was really being good, Your Honor. I think she just got better at not getting caught because she's still using.
Keep going, Mr. Stapleton.
Thank you, Your Honor. Defendant's original sentencing guidelines were 10 to 23 months. The defendant was originally sentenced to 365 days jail. She currently has 308 days credit. She was sure of the probation term she was given.
Let me take a quick look here. Yeah, 24 months. Looks like it should be done in July.
Okay.
Yeah, July 25th.
Okay. The defendant, like I said, is out of jail credit. So there's not a whole lot we can do in this case, I believe. I don't think we can take away good time credit for,
No, I got it. What do you think I should do with probation? That's really the issue.
I think we should continue probation.
Right.
Fines and costs be preserved. She has yet to pay anything on her fines and costs. Continue probation, and then we can keep her on until that July date. 308 days jail, 308 days credit.
I'm going to give her, all right, I'm going to give her the 365 with 308 days credit, which means she's already maxed out the sentence anyways.
That sounds good.
Ms. Rock, you have the right to make a statement before I give you a sentence. Let me explain though. I can't give you any more jail. So you're going to get let out today.
Oh my God.
All right. I by law, I have to. It doesn't make any sense, but by law, I have to. Do you wish to say anything?
Yes, I do, Your Honor.
Go right ahead, ma'am.
So in March when I got out, I was doing really good. I was doing awesome. I had been clean for a year and 9 months. I did make a slip, and it will not happen again. And I appreciate you for making me learn.
All right.
You taught me a lot.
I hope so, Ms. Ronk. Courtrooms are not always about, and judges are not always about punishment. It's always about balancing. That's why we look at punishment. We look at deterrence. We look at protection of society, but we also look at rehabilitation of the individual, because every person's life has value and it matters to this court, and I want to see you improve. Okay, well, Ms. Rock, I want to make sure you understand something, and I do not at all intend this to be considered a threat, because so far you made it a year without getting in trouble. That's great.
I'm honestly
But the law-
appreciative of myself.
All right, well, the law says, and this is kind of odd, because of your probations and this being your what's called only your third technical, the law says I can't give you any jail. It's kind of funny. If you had one more violation, then I could have sent you to prison. Now, that's not a threat, but I want you to know between now and July, you want to make sure that you get back on that right path, that you are continuing to stay off of controlled substances, that you are continuing to improve your own life. Okay, ma'am?
I sure will, Judge Honor.
All right. The court therefore sentences the defendant as follows. The court preserves all fines and costs, continues probation as previously set by this court, sentences the defendant to 365 days with 308 days of credit. Ms. Ronk, as long as you have received all your good conduct time, the jail should give you the 60 days, which means you should be let out today. Okay? No, don't worry. I gotta sign some paperwork and get it over to them. All right, so it should be though today. All right, all right.
So I should
Ms.
go
Ronk,
home?
oh, hold on. Well, I don't care where you go as long as you don't get in trouble. I just want you to know this, Ms. Ronk, you have the right to appeal your conviction and sentence. That is typically done by filing a claim of right to appeal. However, based upon the original plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want this court to consider appointing an attorney to assist you, you must let me know within 42 days. Do you understand, Ms. Ronk?
Yes, sir, I do.
Jennifer, good luck. Let's hope.
That was just too much. That was too much. Oh, it's not like she hadn't served anything. You know, she was in there 308 days, I think he said. So, you know, the judge didn't really feel right about not being able to sentence her to anything, but she has already done time. Yeah, getting moon pictures and star pictures are nearly impossible on cell phone cameras and stuff. But I am going to go get a firsthand look at the eclipse. So I'm going to keep this short and sweet. Hopefully the clouds won't be blocking everything up, because I'd really love to see it. So apparently I'm told on good authority that about 20 minutes from here is a gorgeous sight. So I'm really hoping that they're not pulling my leg. Thank you guys for coming out and enjoying some court with me. Yeah, it's the blood moon eclipse. Now. Tonight. Yeah. Like in an hour and a half for me. And I got to shower. And then I gotta go. You were kidding about what? I plan on taking you pictures. Or were you kidding about the text messages that you sent me like 3 times in a row? Same one. Same picture. I love you so much, Eileen E. Carlin. I love you. Oh my gosh, Jody Gardner and Papa Les. So good to see you. Oh my gosh, Ava, honey. I know I'm loud. Oh my gosh, I love you guys all. I love you so much. Thank you so, so much. Be safe, be well, sleep sweet, and much love.